Participants, may I request you to turn on your camera? Good morning, Mr. Witter. Good morning, Mr. Xavier. Judges, before we begin, I would like to request for you to change your prefix according to this format, please. Thank you, Judge. We are currently waiting for Mr. Gavin. Our match will begin shortly, judges. Judges, while waiting for Mr. Gavin, can we proceed to the dry run session?
Yeah, sure.
All right, thank you, Mr. Xavier. Lead counsel from appellant, can you hear me and see me?
Yes, loud and clear.
All right, thank you. Co-counsel from appellant, can you hear me and see me?
Yes.
All right, thank you. Lead counsel from respondent, can you hear me and see me?
Yes.
All right, thank you. Co-counsel from respondent, can you hear me and see me?
Yes, I can hear you and see you.
All right, thank you. Mr. Xavier, can you hear me and see me?
Yes, I can.
Okay, thank you. Mr. Witter, can you hear me and see me? All right, thank you. Good morning, Mr. Gavin. Mr. Gavin, can you hear me and see me?
I can hear you. Can you hear me?
Yes, yes.
Ah, great. Okay. Sorry. Let me just read him. Hi, Xavier. Morning.
Hey, morning, Kevin. How are you?
Okay. Not too bad. Yourself, man?
I'm very well, thank you.
Ah, okay. HR2. So sorry for being late. It's just, you know, with the flooding and all that. I mean, that had nothing to do with me being late, but
I was just thinking, how's that work?
actually, my neighbors got caught in the flood.
Oh dear.
They went out for a wedding yesterday. Unfortunate, you know, got caught in the flood, and that's it.
It's quite bad, yeah. It was quite bad around Shala way and all, yeah.
Yeah. But anyway, how have you been keeping, Xavier? Sorry, everyone. I just haven't seen Xavier in a long time.
Very busy, lah, bro. Just knocked off this week. After this is the Christmas week, the New Year. So I'm hoping nothing will explode at the office, but it's been crazy busy the last for a while, yeah.
That's good, lah. Much better crazy than not, you know.
Yeah, absolutely.
Yeah. Witter, nice to meet you as well. I don't think we've had the pleasure of meeting in person. I can't hear you.
Yeah, I can't hear Witter.
Still no sound, Witter.
Witter, you want to try and say something? Because we can't hear you, I think.
Yeah, no sound.
So while Witter sorted out, participants, enjoy yourself. Don't worry, Gavin is the nasty judge. I'm the nice one.
Yeah. Good cop, bad cop routine. Faiz, would it be all right if we ask the participants what year they're in and
Sure, Mr. Gavin.
maybe we start with I see Tan Kai.
Yes, I'm in year 3 right now.
Year 3, I see. And your co-counsel is?
Year 2.
Who is that?
Miss 𝐸𝐦.
Okay, right. Nice to meet you. And you have a researcher as well.
Yeah, we have a researcher. She also in year 2.
I see. Okay, nice to meet all of you. And
Nice to
for
meet
lead
you.
counsel, Parmanjit?
Yeah, we are all from year 2.
Year 2. Okay, right. It's a very good thing to have all these moots. I think Xavier and I can commiserate. When we were growing up, I think there was one moot they had, and it was an internal moot amongst the team, all the students in our year. That was it.
It was that sad, man.
Yeah. Now I see there's at least 7 or 8 moots running all at the same time.
Yeah.
An excellent thing for all of you.
And this was very well organized. I think all the guidelines was very well organized. Yeah.
Yeah. The memorials and all that, I thought it was very well done.
Yeah.
Okay. Do we start right on the dot at 9, Faiz, or?
We can start at 9:20, Mr. Gavin.
Okay. So can I step out for a while? I just need to go and do a few things. Is that okay if I come back in a while?
Sure, Mr. Gavin.
Okay. Gents, I'll catch up with you in a while.
All right, man.
Okay.
So what are we doing right now, Bidif?
We are waiting for Mr. Witter, Mrs. Xavier.
Okay. All right. So I hope none of y'all are reading off your script, or else you'll put me to sleep, you know.
Sorry, just a test, guys. So can you hear me?
Finally, Witter, we hear you. Fantastic.
Okay. Sorry, guys. Stupid internet lah.
Right, all good to go? All right, Mr. Gavin.
Sorry, I just ran down to get a coffee. Yeah.
Thank you, team and judges, for joining us, and welcome to the preliminary round one. Sorry, my apology. To the semi-final round of the Dato Hashim Hamzah Internal Moot Court Competition. My name is 𝐒𝐴𝐴𝐵 and I'll be acting as the bailiff for today's session. Before we begin our session, I would like to provide a brief of the rules. Each team is allocated maximum of 30 minutes to submit their issue, including rebuttal and sur-rebuttal. And counsels are kindly reminded to mute your microphone when you are not submitting and turn on your camera at all times. While waiting for the judges to join us before this, we have already asked the counsels to fill in their time allocation plan. I would like to copy it again for the judges to view. Right, now I would like to repeat and confirm the time stipulated by both teams. As for the appellant, the lead counsel will be taking 12 minutes, the co-counsel will be taking 15 minutes, and they reserve 3 minutes for rebuttal. And as for the respondent team, the first counsel will be taking 13 minutes, the second counsel will be taking 12 minutes, and they reserve 5 minutes for sur-rebuttal. Judges, we have already privately messaged you the score sheet link. Can you access it?
Yep, all good on my side.
Yes, this is in the Google Drive, isn't it? Bailey?
Yes.
Yeah, I
Yes,
have
Mr.
it already. Yeah.
Right.
So we will just key it in and it will automatically save on Google Drive, right?
Yes.
Okay.
Oh, wait, do we have to? I see. So download and upload it back into that Google Drive,
No,
right?
no, that's not required.
What do we do with the score sheet after? Pass it to you?
The scores are uploaded instantly, automatically, and then we will open it together with you.
So Kevin, if you use the same link in the Google Drive to open it,
I see.
It's a Google Doc. So when you key in, it automatically saves. Yep.
Okay, no worries. Thanks a lot. I'm so used to download and then comment.
Yeah.
You know. Yeah.
Mr. Victor, can I confirm that you have received?
Yes, I have the link. So it's in the link, right?
Yes.
Okay, all right.
All right. Judges, you may fill in the score sheet throughout the session, and should you have any inquiries, feel free to seek clarifications from us. That's the end of our briefing of rules. Our session will begin now. Participants and judges, I thank you for joining us and welcome to the semi-final round of the Dato Hashim Hamzah Internal Moot Court Competition. We are honored to have Mr. Gavin J. Ananjayapal as the presiding judge, followed by Mr. Xavier Joachim and Mr. Witter Yi. The match between Team 2103A and Team 211R is now in session. The court proceeding may start now. Panel of judges, may I now invite the appellant's lead counsel to begin?
Please.
We will now invite the appellant's lead counsel to begin your submission.
Much obliged. Good morning, my lords. Before I begin, may I confirm that am I audible?
Yes, you are.
Okay. May it please the court, my name is Tan Kai and I appear on behalf of the appellant with my co-counsel, Ms. Ng Wei Wen, and also my learned friends for the respondent, Ms. Parmanjit, and her co-counsel, Mr. Jafran. I'll be addressing for the first and second issues. I'll be speaking on this matter in 12 minutes. My co-counsel, Ms. Ng Wei Wen, will be addressing for the third and fourth issues, and she'll be speaking in these matters for 15 minutes. We're reserving 3 minutes for our rebuttal. Before I begin, may I ask whether a brief summary of facts is needed?
That would be helpful, counsel. Would it be helpful for your submission?
Depends. Not really.
I don't want to cut too much into your time, though. You've got limited time. So why don't you jump straight to it? Why don't you jump straight to your issues?
Much obliged.
Unless Mr. Xavier or Mr. Yi, my learned brothers.
I'm fine. I'm acquainted with the facts.
I'm fine. Please proceed, counsel.
Much obliged. The appellant will hereby begin with the reasons that the amendment should not be allowed to include fresh evidence based on 3 grounds. By applying to the landmark case, Yamaha Motor Co. Limited and Yamaha 𝐸𝐻 stated that there are 3 basic questions that should be considered in order to determine the existence of the injustice. The first question is whether the application is bona fide. According to paragraph 20 of the Moot problem, the applications of amendment was filed more than 1 year later by the respondent after the pre-trial stage, which consisted of an undue delay in making the applications. Therefore, there is a lack of bona fide for the intentions of the respondent. Next, the second question is whether the prejudice caused to the other side can be compensated by the cost. The prejudice here...
Ms. Tan, if I may just ask a question.
Sure.
The application was moved late because they only found out the identity of the maker of the note rather late. So wouldn't that be a good reason? Because the moment they found out the identity, they immediately filed the application.
In order to, my apologies, my lord, to understand, to answering your questions, we understand that the respondent just found out the identity of the writer after after the pre-trial stage of the proceeding.
Yes.
However, the appellant wants to submit that there is an undue delay because the respondent, they already have the knowledge since before the proceeding that the identity of the writer is the high committee of the vaccine company, which is our company. Therefore, we believe that there is a reasonable, the respondent should take reasonable steps to follow the to get to know who is the writer even earlier. So the appellant wants to submit that there is an undue delay. So there's a lack of bona fide in this submission, in these applications.
I see. Okay, thank you.
Much obliged. So the second question is whether the prejudice caused to the other side can be compensated by the cost. So the prejudice here means that if the amendment is allowed, the party affected will be unable to persuade or defend the suit. Therefore, by applying paragraph 21 of the Moot problem, where the appellants will be unable to prosecute or defend the claim if the fresh evidence which contains the writer's identity is allowed to be included in the pleading, and it may lead to the prejudice to the appellant. Moving on to my third ground.
Sorry, how the appellant is prejudiced?
Yeah, that's exactly my question too. Maybe you want to explain how it's the prejudice plays out.
To understand to answering the questions from the bench, the prejudice will appear by applying to paragraph 21 of the Moot problem because there is an undue delay in making the applications. Therefore, it may waste the time of the appellants and the court. Not only that, the undue delay without the reasonable explanations of the applications can also be said as an abuse of the process of the court.
How is it an abuse of the court process, Ms. Tan?
This can also be explained with the amendments to include the identity of the writer. It will not provide any new cause of actions. As referring to the case of China Orient Assets Management Corporations and Alexma Corporations and 𝐸𝐻, the judges did not agree for the plaintiff to introduce a new cause of actions in respect of the applications, where the statement of claim while the character of plaintiff's suit is still the same. Therefore, by applying this case into our current case, the amendment to include the writer of the writer, to include the identity of the writer, did not bring any new cause of actions. Therefore, the appellants want to submit that there is a there's an undue delay and is set as an prejudice to the
Mr.
appellant.
If I may just interrupt here, but
Sure.
an introduction of amendment to the pleadings is not only for the purposes of introducing a new cause of action. It's to introduce a fact that is relevant, which will later be proven in trial. Given that the heart of the issue is the statement made by Dr. Chua in relation to the test, right? The efficacy test. The identity of the person who revealed that there was inaccuracy in the test. Don't you think that's a relevant fact?
To answering the questions for my lord, because there is the respondents already have the knowledge that the identity of the writer is a high committee from the from our company. Therefore, it does not make any difference if they include the names, the identity of the writer into this pleading.
So if it doesn't make any difference, there's no prejudice to the plaintiff, right? To the appellant, right?
No, it's an prejudice to us because there is an undue delay, so it may waste our time in these proceedings.
So would I be correct to say then, Ms. Tan, that firstly, they could have had with reasonable diligence found out the identity, they did not. And secondly, even if they did find out, including the name of that person into the proceedings is relatively unnecessary. Would that be a correct submission?
Yes.
All right. Okay.
Much obliged. So moving on to my third ground, the third question is whether the amendments would not in effect turn the suit from one character into a suit of another and inconsistent character. So according to paragraph 25 of the Moot problem, the amendment to include the identity of the writer for an anonymous letter in this case will have the possibility to change the character between both parties. So the appellant wants to point out that the inconsistencies here means that it will likely to influence the defamation claim in this case. This can refer to the second element of defamations where the words are referring to the plaintiff. Therefore, the appellant wants to submit that the High Court was erred in making the judgment whereby the fresh evidence should not be allowed to be added into the pleadings because the elements have not been fulfilled. So my lord, with your permissions, may I proceed to my second issues?
Yes, please.
None
from me, unless brothers have.
I'm good.
I think from me, so please proceed.
Much obliged. Next, to submit for the second issues, the appellant will hereby begin with the reasons that the agreement cannot be held frustrated based on two grounds. The first ground is the element of frustrations have not been met. In order to constitute the frustrations, there are three elements that should be met. The first element is the promisor realized as having frustrated of the contract must have been one for which no provisions has been met in this contract. So as referred to part B, which is paragraph 8 to 11 from the Moot problem, there is no provisions met in this contract. Therefore, this element is said to be fulfilled. Second, the event relied upon the promisor must be one for which the promisor is not responsible. In this case, the nature of restrictions and the amendment was on the considerations of the critical side effects by the Mavex vaccines. Therefore, the appellant has the responsibility in the change of law where they are the company that developed and processed the Mavex vaccines. However, the respondents here is also liable to the frustrations because they have breached their part of performance in the contract as stated in part D, paragraph 8 to 11, from the Moot problem when they refuse to pay the outstanding amount at first.
But Mr. What about the fact that your client, it was subsequently discovered, had falsified, well, not falsified, but been creative with the clinical trials? There were no accurate results pertaining to the efficacy of your client's vaccine, so on and so forth, which wasn't made known to the hospital or Dr. Chua.
My apologies, my lord, when you rephrase the questions.
It was subsequently discovered that your client wasn't completely truthful insofar as the efficacy of the vaccine. how efficient the vaccine was. I think that was the subject matter of the note that went out and all that. So, how do you reconcile that with your position insofar as frustration is concerned? Because if the company, the hospital had known that the vaccine was not so effective and there's an error on your efficacy, would they not have purchased your vaccine?
Sure. To answer the questions from my lord, we understand the concerns that if they follow the we did not provide accurate statement at first. However, the appellant wants to submit that the respondent, they did not take proper stage to follow out and did not make sure the statement that was true, because they couldn't find out the identity of the writer at first, and it may say as an defamation for us.
I see. Okay. All right. Thank you.
So moving on to the third element, which the third element is of the frustration is which the event which is said to discharge the promise must be such that it renders it radically different from that which was undertaken by the contract. It means that the parties will be discharged from the further performance of the contract if the changes of circumstance could lead to the radical change in their obligations under the contract. According to paragraph 14 of the Moot problem, my apologies, my lords, since my time is running out, may I have 2 minutes to sum up my submissions?
Not a concern with me, Mr. Xavier.
Yeah, please proceed. No problem for me.
Much obliged. So according to paragraph 14 of the Moot problem, the revisions of the statute has no significant impact either on the registration of the license or the verifications of the vaccines. So by applying to the case of Ramli Zakaria and government of Malaysia, the change in the age group from over age 12 to age 18 to 65 of the vaccines is not the essence of the contract. And at the same time, the Drug Control Authority, they have provided assurance that our vaccines is still safe to be used. Therefore, the contract is still considered valid and it cannot be said as frustrated because it did not render any fundamental change of the original obligations. Moving on to my second ground, that the contract cannot be held in frustrations where the self-induced does not bring an agreement into the frustration starting from paragraph 24 of the submissions. The self-inducing is that one cannot rely on the doctrine of frustrations if all negligence has breached the contract or prevent parties from performing the contract.
But counsel, if I may just interrupt, the self-inducement is in respect of the supervening event. Here in this case, the authorities amending the law. That was not caused because your client did not, the response did not want to pay. So I think the self-inducement you got to, it's in respect of the supervening event, not in respect of the contract, you see. So that's how you judge the timing of it, is it? Isn't that right?
Yes. To answering my lord's questions, the self-induced here, we may explain it as the responsibility from by the appellant and the respondent as well. So because the respondent, the amendment of the law, the change of law is on the concerning of the efficiency of the vaccines. Hence, since we are the one, our company, the appellant, is the one who provide the vaccines and to develop and to process the vaccines. So it makes sense as the responsibility of the appellant. So it makes sense as a self-induced. And also for the respondent, since they did not, they refused to pay for the outstanding amount before it was claimed as frustration. So therefore, we may say that it is a breach of performance on the respondent. Therefore, the appellant wants to submit that there is a self-induced in this case, and it cannot be said as frustrations.
I see. So would I be correct to sum up the argument as being that they didn't want to pay well before the supervening events occurred? Which is why, whichever way you cut it, there is no frustration here. Is that your argument?
Yes.
I see.
Much obliged.
All right.
So in this regards, the frustrations here can consider as self-induced, and in this case, the respondent is still liable to the outstanding payment. Therefore, the appellants want to submit that the High Court was erred in making the judgment, whereby the agreement should not be held frustrated based on the submission as well, while not all the requirements have been met and with the existence of self-induced as well. So if there's no other assistance that I could render to this honorable court, may I invite my co-counsel to submit on the third and fourth issues?
No questions from me.
None from me too.
None from me.
Much obliged.
Before I begin, just check with my lords. Am I audible?
Yes.
Yes.
Much obliged. May it please the court. My name is 𝐸𝐦, co-counsel on behalf of appellants. I'll be submitting the third issue and fourth issue before this honorable court. My lords, the appellant's positions on the third issue is the statement made by Dr. Chua in the press conference fulfills all the elements of defamation. This issue will consist of three parts. To establish defamations, there are three elements that must be fulfilled. Firstly, the statement made by the second respondent in the press conference is defamatory. Second, the statements made by second respondents in the press conference is referring to the appellant. Thirdly, the statement had been published. I'll start with the first element. Firstly, the statement made by second respondents in the press conference is defamatory. The learned judge in St. M. Strange laid down the criterion by which words are to be considered capable of being defamatory are the words that expose the other party to hatred, ridicule, and contempt. The judge in Lau Chi Kwan and Cho Song Xiong also opined that the test of the effect on a hypothetical average reasonable man can be used to restrict the scope of defamations. And the judge cited Lee Tam and Rank that to determine whether the words are defamatory, it should be proved that the words produce a bad impression on the mind of average reasonable man. The first element is fulfilled according to paragraph 22 of the Moot problems. When the press...
Ms. Ng, in the press conference, Dr. Chua didn't actually say the name Vax Farm.
Yes.
He didn't actually say that, because I'm looking at what he said. He just said it's come to my knowledge that one of the main vaccines used in our country, etc., will cut all ties with the said vaccine supply. He didn't actually name Vax Farm Berhad. You know, I'm thinking if he had other suppliers or other persons supplying them with vaccines, how do you link this statement with Vax Farm?
My lords, I understand your concerns, and I will express your concerns in my second round of this issue. So
I see.
I back to my first element. So the first element is fulfilled because when the press conference went viral and public assumed that it referred to the appellants, although the names of Vax Farm Berhad was not mentioned. The statement has the tendency to cause a reasonable man to look down upon the appellants. And if we refer to last sentence of paragraph 22 of the Moot problems, the statement tarnished the reputation of the appellants. So when the words are defamatory of the appellants due to inference or implications of a reasonable man, this is when the words are described as giving rise to a false innuendo. Therefore, the statements made by the second respondent is defamatory. My lord, to understand your to answer your concern just now, we further submit that the statements made by second respondents in the press conference is referring to the appellants. To an ordinary man who has knowledge of the necessary facts, there is no doubt that the article referred to the plaintiff. Moreover, we look into case David Sims and Canavan. The judge laid down a test to determine whether a statement which did not specifically name the appellant amounted to defamation. So the test is, are they such...
Counsel, but isn't it on the facts that that the respondents were also distributing drugs from other manufacturers? Correct me if I'm wrong, but is that on the facts?
The
respondent, right, was distributing vaccines from other suppliers. Was that on the facts?
the appellant is one of the national suppliers of the vaccine, but it is not stated in the Moot problem that the appellants did supply the vaccines to other company or other hospital.
What about Blue Wing?
Yeah.
Boeing is another vaccines from
That's
another.
right. So the respondents were supplying vaccines, were distributing vaccines from other vaccine manufacturers as well, isn't it?
The supplier, you mean the appellant?
𝐸𝐴𝐻𝐸𝐴𝐻 was also distributing vaccines from other manufacturers, correct? So
yes,
I think my learned brother's concern just now was in regards to, could it be that he was referring to the other vaccines that he was distributing? There's nothing on the statement that suggests he was speaking about Vaxfarm's vaccine.
I understand your concern, my lord. So to answer your questions, we refer to the case of Dato Anas bin Khatib Jaafar and Sharifuddin Mohammed and others. The learner just cited the case of AJA Peters and 𝐸𝐽. In the case that the plaintiffs are not expressly named, they may still be considered to refer the plaintiff if the ordinary sensible reader with the knowledge of special facts could and did understand them to be referred to the plaintiff. We refer back to paragraph 22 of the Moot problems. After the press conference went viral, the public assumed that it referred to the appellant and it is sufficient to fulfill the second element.
I see.
In addition, we refer to paragraph 7 of the Moot problems. There is a long-standing business relationship between the appellant and respondent. So the respondent purchased the Mevax vaccine from the appellants. So when these external facts be combined by the fair-minded public together with the statements in the press conference, the public have rational grounds for believing that the statement was referred to the appellants, although the appellant's name was not mentioned. Therefore, we submit that the second element is fulfilled. We move to the third element, which is the statement had been published. So publication is the dissemination of defamatory works to a third party other than plaintiff. Moreover, in a Court of Appeal case, Dato Sri Dr. Muhammad Saleh Ismail and Nurul Izzah Anwar, the defendant made statements in a press conference too. The learned judge held in paragraph 28 that the imputed words in the press conference were published. Therefore, the statements made by the respondents in the press conference amounted to publishing. So in short, the respondent fulfills all the three elements that must be established to prove defamation. Therefore, the learned judge of High Court made the correct decisions in this issue. My lord, with your permission, may I proceed to fourth issue?
Yes, please.
Much obliged. So I will continue to submit the fourth issue. Dr. Chua is not entitled to the defense of Raynaud privilege. This issue will consist of two parts. Firstly, the respondent do not have a legal, moral, or social duty to the public to publish the statements under the duty test. Secondly, even if the statements were uttered on a matter of public interest, the respondent failed in the test of responsible journalism. I'll start with the first ground. Firstly, the respondent do not have a legal, moral, or social duty to the public to publish the statement under the duty test. In Raynaud and Times Newspaper Limited, there are three stages set out to determine whether the Raynaud privilege can be raised. There are the duty test, interest test, and circumstantial test. However, we will only adopt the duty test and interest test, and also the test.
Counsel, I think we're quite familiar with the Raynaud test. I think more importantly, you see, the Dr. Chua here was a former health minister, he's currently an MP. So applying the Raynaud test, don't you think he's got a public duty to inform, particularly when the issue is as serious as this pandemic, right? The public would want to know about the efficacy. Everybody wants to know about the efficacy of the vaccine, right? So don't you think he has a public duty, or you disagree with that?
So my lord, to answer your concerns, we contended that when Dr. Chua makes his statements in the press conference, he was acting on behalf of Eastern Cape, but not the member of parliament. If we may draw the
but he was the MP, right, at that time? So how do you know which hat he was wearing at that point? I mean, it's quite speculative, isn't it?
Yes, we agree that Dr. Chua is also the member of parliament, but we submit that when Dr. Chua made the statement, he is in the capacity of Eastern Cape. If we may draw the court's attention to paragraph 21 of the Moot problem, there are continuous acts by Dr. Chua. Why we say so? After receiving the email, Dr. Chua contended that if he had known about this matter, Eastern Cape would not have entered into an agreement with vet farms. And further, he then launched the press conference and made the defamatory statements. So we contended that when Dr. Chua made the statements, he was acting on behalf of Eastern Cape, not the member of parliament. Moreover, he will only make a statement which is in favor of him and Eastern Cape. This is because we refer to the paragraph 7 of the Moot problems. The financial department of Eastern Cape anticipated that the sales of Mavax would decline 70% after the happenings of the unexpected news on the amount of people who suffered side effects after receiving the vaccines. Besides, Dr. Chua has pressure on this matter because it will affect his interest and also the financial of Eastern Cape. Therefore, Dr. Chua will definitely not make a fair statement which is related to public interest. Back to my submission.
Counsel,
Yes, my lord.
and the defendant who is not a journalist relies on the defense of qualified privilege, Renault privilege.
Okay, my lord, we agree that not only everyone is entitled to defense under Renault privilege, not only the journalists, but this will be clarified in my second round of the submissions. Even if the respondent has the social duty to publish the statements and the matter is altered on a public interest, the second respondent has failed in the test of responsible journalism, and due to that, he is not entitled to defense under Renault privilege. We go to my second graph of my.
So you're saying he was acting in his capacity as MD of Vax Farm, and in that capacity, he has no interest in publishing. He was only securing the interests of Vax Farm and not of the public at large. Would that be correct, Ms. Earl?
Yes, yes. This is what I mean. And we further submit that even if the statements were altered on a matter of public interest, the respondent failed in the test of responsible journalism.
Because he added on, well, for lack of a better term, he added on his own personal experiences insofar as the vaccine is concerned. Is that your position?
Sorry, my lord,
as in he's not responsibly reporting on this event. Is that what your submission is vis-a-vis responsible journalism?
My lord, Dr. Chua don't have the responsibility of journalism to publish the statement because he did not take reasonable steps to verify the identity of the unknown reader. Also, he failed to provide an evidence on the truth that if he claims that the vaccine's efficacy results is inaccurate, but he never provides an evidence on this issue.
I see. Okay. So he just had the note. He didn't know who sent him the note. It could have been a poison pen letter for all he knew. Subsequently, he found out. But at that material time, he just held a press conference and ventilated his views.
Yes, my lord, this is our stand. So in a federal court case, Syarikat Bekalan Air Selangor Sdn Bhd and Tony Phua Kiang Wee, the learned judges also opine that the responsible journalism must meet to raise the Renault privilege. Therefore, we contended, we also look into the case of Raoult Australia Gold Mining, Sendirian Berhad, and mkini.com, Sendirian Berhad. The learned judge opined that responsible journalism is focused on ensuring that the journalists take reasonable steps to in relation to the truth of any allegations which they which they report. So there is no, if the publishers has not taken reasonable steps to verify the truth, there is no duty to publish, and the public have no interest to receive the statements and the words. We contended that the statement made by the respondents is baseless. It can be shown that from the fact that the respondent had not taken reasonable steps, as I mentioned just now, to verify the identity of the unknown reader, and he also failed to provide any relevant evidence. Therefore, even if he, my lord,
Listen, your time is up. Would you like extra time? Do
yes,
you have
yes, my
much
lord.
more?
My lord, I would like to request for an extension of 2 minutes to conclude my submission.
That's all right with me, my learned brothers.
Yeah, that's fine with me too.
That's fine.
Much obliged, my lord. Therefore, even if the second respondent spoke on a matter of public interest and the public had a corresponding interest in receiving the statements, the second respondent failed to comply with the test of responsible journalism, as he failed to take reasonable steps. Therefore, Dr. Chua is not entitled to the defense of Reynolds privilege, and the learned judge of High Court was urged in making this judgment. In conclusion, my lords, the appellant respectfully submit that, first, the amendment's pleading should not be allowed to include fresh evidence. Second, the agreement between the appellants and respondents cannot be deemed frustrated. Third, the statement made by second respondent in the press conference fulfills all the elements of defamation. And lastly, the second respondent is not entitled to the defense of Reynolds privilege. The appellants praise this court to judge in favor of appellants. If we have no further assistance to this court, then that concludes the appellant submissions. Much obliged.
Thank you, counsel. No questions from me.
No questions.
Much
Thank you.
obliged. Much obliged, my lords.
Can we hear the respondent, please?
Okay, before I start, may I confirm that I'm audible and visible?
Yes, you are, Ms. Paramjit.
Okay, thank you so much. May it please the court, my name is Parminjit Kaur as the lead counsel, and together with me is my co-counsel Muhammad Safran Amir. It is our honor to appear before the Court of Appeal pleading on behalf of the first and second respondents, Eastern Care Specialist Center and Dr. Chua Kai-Ming respectively. I'll be speaking for 13 minutes to address the first two issues, while my co-counsel will be speaking for 12 minutes to address the third and fourth issue. The rest of 5 minutes will be reserved for rebuttal. I'll now start with the first issue, where we believe that Eastern Care can file for amendment of pleadings to include fresh evidence, and I will advance 3 submissions in this regard. The first concerns the fact that the amendment complies with Order 20, Rule 5 of Rules of Court 2012. Secondly, the amendment was done within a reasonable
Ms. Kaur, could you slow down a little bit? I'm just writing it down.
Oh, yes, sure.
Yes.
Much obliged.
So the first point was complies with Order 20. Number 2?
Yeah, the first point is that the amendment complies with Order 20, Rule 5 of Rules of Court 2012.
Right.
And the second, the amendment was done within a reasonable time.
Okay.
Third, the act was bona fide. My lords, I will now explain on my first submission. Now, Order 20, Rule 5 of Rule of Courts 2012 allows pleadings with leave, where any parties can amend their pleadings after the stipulated period of limitation, as long as the court thinks it is fair to do so. Further, when Order 15, Rule 6, Subsection 2, Part B 1 and 2 is read along with Order 20, Rule 5, it states that parties may include persons who should have been joined as a party or whose presence before the court is required to guarantee the issues in the case are resolved and adjudicated on effectively. Hence, the identity of the anonymous writer, the former Director of Research and Development of Rexfarm, is a crucial amendment because the certainty in the identification of the writer implies that his allegations are reliable and were made in good faith. This shows that the director's presence in the present dispute is necessary to affirm that Rexfarm had failed to provide an accurate study.
Counsel.
Itself. Oh, yeah. Yes, my lord.
Order 15 is regarding joinder of party, isn't it? How is it relevant to your amendment?
Sorry, my lord. I didn't catch that. Can you repeat?
Order 15 is provision regarding joinder of parties in a proceeding. So how is it
It is-
relevant to Order 20?
To answer that question, my lord, it is relevant because we would like to include the presence of a party whose identity is reliable and relevant to the facts of the case.
But
So
counsel,
you
there's a difference between adding wanting someone as a witness and wanting someone as a party. In this case, a defendant. I think that's what my learned brother is getting at. Is he?
exactly.
To answer the question, my lords, it's that when we through Order 20, Rule 5 of the Rules of Court, we can add our new evidence, which is the identity of the person.
If I'm not wrong, Ms. Kaur, you only amended to include the identity of the writer. That was about it, right?
Yes, the new identity.
I see. Because before you pleaded the document, but you didn't have the identity. Then subsequently you discovered the identity, and then you pleaded the name of the creator of the note.
Yes, my lord, that is true.
Director of R&D. That was the only amendment, correct?
Yeah, to include the identity
and
of
the
the
person attended, he gave evidence and he said that he did create the document.
Yes, my lord.
Or I think that may be beyond your memorials, but it's a reasonable assumption for us to make. Okay.
So to be clear, you're not adding this individual as a party to the suit, not as a defendant to the suit. Only you want to add his name into the pleading so that you can then lead evidence in trial. Is that right?
Yes, that is exactly it, my lord.
Okay. So Order 15 then would have no application. It's just Order 20. But go on now. Go on.
Okay.
Yeah.
Yeah. So so this shows that the records present in the present dispute is necessary to affirm that Wexam had actually failed to provide an accurate study since the director himself was involved in the clinical study. Now proceeding with my second submission on this issue, there are three basic questions which the amendment application should comply with, and these questions are based on the federal court ruling in the case of Yamaha Motor Corporation Limited and Yamaha Malaysia's name Berhad and others, about how the amendment of pleadings can be filed at any stage of the proceedings, particularly before trial. The three questions are whether 1, the application is bona fide, 2, prejudice caused to the other side can be compensated, and 3, will turn the suit from one character into another that is inconsistent. Now, in the present case, there's no argument before us to suggest that the first respondent's application was made mala fide, or that whatever prejudice that might be caused cannot be compensated by cause, nor by such amendment, the original suit will be turned into a suit of different and inconsistent character. Further, in the case of Hong Leong Finance Berhad and Low Tiang Ho, the federal court measured the time between the date of amendment application and the date of trial to determine if the application was made within a reasonable time. Now, in the present situation, Eastern Care did not cause any unreasonable delay in filing for the amendment application, since the application was done in the middle stage of the court proceeding. So there is still a reasonable amount of time left before the actual trial. And
So, but counsel, the appellant obviously is arguing just now that if you had done some due diligence, if you had done some checking around, you may have obtained the identity earlier, and so that's how they are couching their delay. That you could have discovered the information earlier. Is it?
Yes, my lord, to respond to this, we did actually take reasonable steps to find out the truth about the writer, which is that our respondent have tried to call the number stated in the letter, but was unsuccessful in reaching out to the writer. However, of course, that is not enough. And 3 days later, our respondent has launched a press conference. Now, two outcomes can be expected from this press conference. The first is that either Wexam clarifies on the issue mentioned in the press conference, or the writer of the letter discloses himself. And to a reasonable man, the fact that, if I may direct my lord's attention to paragraph 12 of the Moot problem, the fact that 98 people were reported to suffer critical side effects after receiving the Mavax vaccine, and 2 citizens were in ICU, 1 dead, and also that the amendment of the license by the Drug Control Authority, these facts, we can infer that it is reasonable for any man to believe that the content of letter is true. So, and we did not, of course, we could have taken other steps, but we have to take into account the consequences of such steps. For example, it may damage the whistleblower, the protection towards the whistleblower, who's actually the person writing the letter. And this can be inferred when the whistleblower, I mean the person writing the letter, at the time of writing the letter, he had a stamp. There was a stamp on the letter which shows that he is used by a high-profile officer of Waxfarm. But by the time his identity was revealed, he was then the former director of research and development of Waxfarm. So we can conclude that he was having some troubles in Waxfarm, and that is why we did not want to damage the protection towards the whistleblower. Yeah, if I may continue. Eastern Care filed an amendment application as soon as the identity of the higher official of Waxfarm was disclosed. If we had known about the identity of the higher official of Waxfarm earlier, there wouldn't have been an unreasonable delay here. There wouldn't have been a delay here. But since we did not know and we only know now, our respondent have filed the amendment application as soon as the identity was disclosed. And coming to my third submission, the act was bona fide. As previously cited in the case of Yamaha Moto, one of the basic questions the federal court stated is whether the application was bona fide. And in the present case, the amendment of pleadings were done in good faith, as the new findings of fresh evidence, which reveals the identity of the writer of the letter regarding the alleged Waxfarm's inaccurate clinical study results, were relevant and necessary for a fair trial. And hence, for the reasons presented, we believe that Eastern Care can file for amendment of pleadings to include fresh evidence. Before I move on to my second issue, are there any questions from the bench?
None from me.
None.
No.
Okay. So now moving on to the second issue, we argue that the agreement between Waxfarm and Eastern Care ought to be deemed frustrated due to the change in law made by the Drug Control Authority. And I have two submissions in support of this argument. First, the change in law made by the Drug Control Authority fulfills all the elements to induce the doctrine of frustration. And second, the radical change in the obligation test confirms the frustration in the contract between Waxfarm and Eastern Care.
So, Counsel, just to clarify, is it your client's position that they want the entire contract frustrated, or only the parts where the drug authorities has prevented by the amendment from distribution?
Starting from that part, which is the frustrating event, we want to hold the entire contract frustrated.
So the entire, so even for those distribution to the citizens where it is not prohibited by law, you're saying despite you being able to sell the drugs to them, you want that part of the contract also frustrated?
Hold on, my lord. Yes.
Okay, carry on.
Yeah. So, my lords, I will explain on my first submission. Section 57, subsection 2 of the Contracts Act 1950, which provides for the doctrine of frustration, states that a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promiser could not prevent, unlawful, becomes void, and when the act becomes impossible or unlawful. The phrase "become void" means that the frustrated contract started as a valid contract, but comes to an end automatically and becomes void upon the happening of the frustrating event. In the Court of Appeal case of One Mo Kolopos Lian Berhad and Selangor Properties Berhad, Justice Gopal Sri Ram stated that there are three elements to apply the doctrine of frustration in the case. First, the event upon which the promiser relies as having frustrated.
Counsel, insofar as the law is concerned, I think we are relatively clear. But what I'd like to query is this. The Act specifies that the drug can still be used on those aged 18 to 65. So the drug still can be used for a particular range of peoples. Now, your client may not be able to vaccinate those above 65 with the drug. And the question I have is this: how is the contract frustrated when you can still use the drug for a relatively large class of people in Malaysia? Because 18 is the starting age up to 65. So you're only omitting older people from that class of people you're allowed to vaccinate. How does that render the contract frustrated?
I'm allowed to answer the question. At first, the suitable age group was for 12 years and above, and now it's limited to 18 to 65 years old. So there's an exclusion of people from age 12 to 17 and also 65 years and above. So this is a radical change, as it is excluding 2 out of 3 age groups, which were supposed to be eligible to take the vaccines.
But your client still can perform that part of the obligation, right? I mean, can still sell the drugs to 18 to 65. There's no radical change insofar as this class of people are, isn't it?
There's still a radical change for the overall contract, my lord, as the contract was based on the consideration in the key descriptions of the Mavax vaccine, which stated that the suitable age group was for 12 years and above. However, now the consideration taken when getting into an agreement with Vaxfarm is there's a radical change, since at first the consideration was 12 years and above, and now turns out they can only sell from 18 to 65 years old.
But if we do a bell curve analysis of ages also, you'll find more people in that age range of 18 to 65. Wouldn't you say that for large, almost 80% of the population still can be inoculated with the vaccine? It's only that, 15% or so. If you need extra time, I'm okay with you having extra time. We've been.
I'm all right.
I would like to request an extension of 5 minutes. I'm really sorry. Sure,
granted. I think everyone's okay. If that extension, so talking about extension, if only 85% can still be performed. Now, frustration is when it's impossible to perform. How would you argue that your contract is impossible now?
Okay, even though that, of course, we may say that 80% can still take the vaccine because it's still available for 18 years old to 65 years old. But the groups who are at risk and who needs the vaccine the most are usually from 12 years to 17, as they're the ones going to school every day. They are the ones involved in a lot of activities in daily life, and also senior citizens. They are more at risk and they are more in need of the vaccine. And our target is the target market for the vaccine is usually to people who need it the most. And now that the Drug Control Authority has amended the regulation and on the license imposed for Vaxfarm.
Did it suspend the license of Vaxfarm?
Yeah, they did not suspend. They just invoke an amendment. Yeah. So now that they have done that, it is unlawful and also impossible to sell it to people outside of the range of 18 to 65 years old. And of course, that alone is
not so much that it's impossible to sell. It's more people don't want to take it, correct? Because of the negative press that has come about. The negative press that arguably Dr. Chua played a big part in bringing about. Yeah. Wouldn't that be correct for me to say?
The ones who do not want to take the vaccine, who choose to not take the vaccine, are those who are actually eligible to take the vaccine and have a choice to not choose it. But for us, there's no choice for the respondent to sell the vaccine or not, because it is now unlawful to do so if they are outside the range of age 18 to 65 years old.
I think, Council, the trouble we're having is to see the impossibility. It doesn't appear there's an impossibility. There appears to be perhaps a reduction in the reach of the drugs to the number of people that your client may have anticipated. So part of the contract can still be performed and part of the contract cannot be performed. So it's not like the entire contract is impossible. Part of the contract may become impossible by the amendment, isn't it?
Yes, my lord, part of the contract becomes impossible. And how do we know if this part of contract becoming impossible is enough to render the contract frustrated? Is by the radical change in the obligation test, where we can see that 2 out of 3 age groups are excluded from taking the vaccine.
Okay.
I see.
So, first, the three elements to apply a doctrine of frustration in a case is: first, the event upon which the promisor relies as having frustrated the contract must have been one for which no provision has been made in the contract. And second, the event relied upon by the promisor must be one for which he or she is not responsible. And third, the event which is said to discharge the promise must be such that renders it radically different from that which was undertaken by the contract. And for the first element, in the present case, no provision has been made in the contract between Eastern Care and Vaxfarm on what has to be be done should there be any change in laws. The agreement simply stipulates that Eastern Care shall make the first payment, which is 50% of the purchase price within 3 weeks to Wexfarm upon the completion of the distribution, while the balance of 50% purchase price will only be paid 6 months after distribution of the vaccines. Now, Eastern Care has fulfilled their obligations, which include their first payment of 50% of the purchase price to Wexfarm before the frustrating event, which is a change in law, happened. And the change in law happened after the formation of the contract. And as such, Eastern Care is free from performing any future obligations, which includes the balance payment of vaccines after the change in law, which rendered the contract frustrated. And this case also fulfills the second element, where there is no self-induced frustration. The change in law when invoking Regulation 17 of the Control of Drugs and Cosmetic Regulations 1984 is based on the Drug Control Authority's discretion alone. The contracting parties did not have any prior knowledge of impossibility. And next, the change in law caused radical difference in the contract between Eastern Care and Wexfarm. Now, as I mentioned earlier, the Mavax vaccines purchased were meant for people aged 12 years and above. However, after the amendment on the license issued to Wexfarm was made by the Drug Control Authority, the eligible age group for the vaccines got limited to 18 to 65 years old. And this limitation concerns 2 out of 3 age groups, whereby change is radical. And to further exemplify this point, we can refer to the radical change in the obligation test, which was applied by the former federal court in the case of Ramli bin Zakaria and Government of Malaysia to determine whether a contract has been frustrated. Abdul Hamid, federal judge in that case stated that a contract is not discharged by frustration unless the changed circumstances make the performance of the contract something radically different from that originally taken. So I will now proceed in my second submission to explain further on how this test confirms the frustration of the contract between Wexfarm to Eastern Care. In the present case, following the amendment on the license issued to Wexfarm, the Mavax vaccine, which was initially meant to be used for age groups of 12 years and above, can now only be used on people from 18 to 65 years old. And this change involves the exclusion of teenagers and senior adults from being able to receive the vaccine. And the only constant age group which could receive the vaccine is those who are adults. And this is a radical change, as after the change in law, 2 out of 3 groups are excluded from being eligible to take the vaccine. If I may direct my law's attention to paragraph 8 of the Moot problem, Eastern Care chose to make an agreement with Wexfarm to purchase their vaccine after taking into consideration the efficacy of the Mavax vaccine and believing that there was a huge potential market. And the basis of these considerations were the key description of the Mavax vaccine stated in paragraph 4, which included the suitable age group for people suitable age group to take the vaccine. If it was known from the beginning that the vaccine is only for people aged 18 to 65 years old.
But if I look at paragraph 8, Ms. Kaur, it's your client, Eastern Care, that seems to have confidence in the vaccine and seems to have confidence in that it will be a good business deal. Now, for all intents and purposes, it appears as if your client, for lack of a better term, got into a bad deal and is now trying to unwind said bad deal. Now, I think your co-counsel will deal with the issue of the statement. But I see your point insofar as that is concerned. Is there anything further you'd like to add on?
Just a little bit.
Because I noticed Ms. Lim has said that your 5-minute extension has expired.
Oh, I'm really sorry. Then I will wrap this up in 1 minute. Yeah,
yes.
Nothing much more to add on. Yeah, thank you so much. So, since if it was known from the beginning that the vaccine is only for people aged 18 to 65 years old, the agreement will not have been made at all, as Wexfarm is not the only vaccine supplier of Eastern Care. And therefore, it is only fair that the contract be deemed as frustrated when there is a radical change and it has become impossible to perform and unlawful as initially contracted for. And hence, we believe that the agreement between Wexfarm and Eastern Care ought to be deemed frustrated due to the change in law made by the Drug Control Authority. If the bench have no more questions, may I call upon my co-counsel to address the third and fourth issue?
Certainly, I have no questions unless Mr. Yee or Mr. Xavier have any.
No questions from me.
No questions.
All right, much obliged. Now I will call upon my co-counsel.
Please.
Third and fourth issue.
So, obliged, members of the bench. Before I start my submission, may I know if I'm audible?
You are,
clear?
Zafran. Could you speak up a bit? It's a bit soft.
Can you hear me now?
Yes.
I'm sorry, I'm having a little bit of internet trouble this morning.
That's not a problem.
I believe now I'm audible.
Yes.
Much obliged. May it please the Honourable Court, my name is Mohammad Zafran Amir, the second counsel representing the respondents. Today, my submission is in regards of issue 3 and issue 4. My lords, issue 3 is whether the statement made by Dr. Chua in the press conference fulfills all the elements of information. And I have only one contention to be made, one submission to be made. And it is regarding the non-applicable of the normal test of defamation. And I believe the court is well aware of the established 3 elements that constitute defamation. And the first element that constitute defamation is that words are defamatory. And this is our contention that the normal classic test can be used in this in the case today, because in normal circumstances, words could be considered as defamatory when it has the tendency to lower the estimation of the plaintiff in the eyes of the public, as stated in the case of Sheikh Hussein Ali against Syarikat Pencetakan Utusan. However, we believe that in today's circumstances, in today's case, it is much more critical and much more important, and it's not it is not a type of the typical case where it is actually done to defame someone, to bring someone down. But I believe this is actually being done as a matter of integrity, as a matter of accountability from the plaintiff itself. And we believe that the normal sets of tests, the normal classic tests used earlier in the reported cases could not be applied in this case, because the appellant is also answerable to the public. And we contend that a better question to confirm whether words are defamatory laid out in the obiter in the case of Chu Peng Cheng against Anthony Teo Ghim, where the judge had laid out where the judge had made the comment where public perception to accountability, transparency and good governance in respect of people either holding office or in a position or who get involved in any affairs of government, and also has more and more.
Mr. Zafran, there's just one core question that I have to ask you.
Yes,
when Dr. Chua was at that press conference and he made that statement, he was acting in his capacity as MD of Eastern Care. Now, when he made that statement, he didn't name Eastern Care specifically, but I think it was common knowledge that he was the Eastern Care only dealt with Vax Farm at that point. Now, I may be mistaken on the facts. I know there's that blue wing vaccine and all that, but that came subsequently.
Yes,
but at that material time, it was only dealings with Vax Farm that were of concern. Now,
yes,
after making that press conference and after making it viral, he then goes around and turns and says that the contract is frustrated. How do I help us to reconcile that position, or help me at least to reconcile that position? How does Dr. Chua's, what I would view as a self-serving statement,
yes, my lord,
how is that not defamatory of Vax Farm?
To answer your question, my lord, is actually the position of Dr. Chua in giving the press statement is as a member of parliament and also the owner of the Eastern Care, where the vaccines are being rolled out.
Well, he can't wear two hats at the same time. He has to choose one hat to wear. So, yes, because if I look at the Moot problem, he is the one who's gone on to this, press conference. He is the one who has gone and said that, oh, because of A, B, and C, we have received this. And at that time, it was just a blank statement. It was just a letter from an unknown writer. You use the official stamp of Vax Farm. It could have been a forged document as well. He had no idea whether it was true or it was not. But he's to say that one of the main vaccines used in our country did not provide an accurate result for its efficacy. We will cut all ties with the said vaccine supplier, and then to further, that goes viral and all that.
Yes, my lord, I understand.
Would that not lead into the fact that he is defaming Vax Farm?
Thank you for the question, my lord. But to answer the first part of the question, actually, about regarding whether Dr. Chua is in regard allegedly defaming the appellant, is where I would like to direct the members of the bench to paragraph 20 of the Moot problem, where it he actually stated that he is not liable of the payment due to the provisions made by the Drug Control Authority, the amendments made by the Drug Control Authority and then only he get the letter with the official stamp of Vaxfarm. Then only he made the press conference. So
But
therefore,
doesn't that seem to lead into the fact that, look, I want to get out of this contract, and I'm going to do everything in my power to get out of this contract?
We believe that the respondent made the statement in the press conference with good faith, my lord, because this issue of vaccine is actually not only issue of interest for him, to get sufficient amount of money from selling the vaccine, but it's also a matter of public security. National emergency has been declared before due to this pandemic of COVID-19. And once he get the letter that stated that the vaccine had provide inaccurate clinical results, therefore he made the press conference. It has nothing to do so before the press conference has nothing to do so when he opined that the contract has already frustrated, because the contract has already frustrated in his belief after the Drug Control Authority had amended the license given, my lord.
So counsel, you're saying that essentially that at the time he made the press conference, those statements would be somewhat justified, given that the drug authority had already issued an amendment to the license preventing the drug from being distributed.
We believe it is not only justified, my lord, but it's actually to one an accurate result from the vaccine provider from Vaxfarm. We believe that I believe that the respondent, when he made the press conference in good faith, he believed as said by the lead counsel of the respondent, where we believe that two outcomes will come after the press conference, where the first one, Vaxfarm, will clarify everything, or the second one, the writer of the letter will come forward, the whistleblower will come forward and reveal himself to the public about the allegations made.
So even if he wore the hat of the company managing director at the time he made, would it be right to say that he still has a duty to inform the public? I mean, let's forget that he was an MP for a moment. Even if he wore the hat, you say that being a company that was supposed to distribute the thing to the members of the public, he had a duty to inform the public?
Yes, my lord. I believe that the respondent has the interest in informing the public, and the public has interest in receiving the communication made, because these allegations are made. These allegations are actually not only concerning the hospital itself, but it concerns the whole nation, and it is part of a public interest, and that I will focus in the next submission of my fourth issue, my lord. And if there are any other questions regarding the third issue, where I have only one submission to be made under this issue, where the normal circumstances the normal test cannot be applied and is sufficient and insufficient to be used in this case between the appellant and the respondent. And we pray to the court that to dismiss the appeal for defamation by the appellant, as the second respondent, with good faith, made the statement to scrutinize the possibility of the intransparent result of the efficacy, my lords. And I believe I may now proceed to my fourth issue, my lords.
Yes, please.
Where I will submit that Dr. Chua is actually entitled for the defense of Reynolds privilege. And first and foremost, Reynolds privilege is a famous case where it is actually laid out.
We're well aware of the law, Mr. Zafran.
Yes, it is publication of defamatory statements with the interest made of the public, my lords. And we contend that under this issue, we have two submissions to be made. And the first one is that non-media individuals can apply this defense, and the second one is the appellant, the respondent has legal, moral, and social duty to inform the public, and the public has the corresponding interest to receive the information that was communicated to him. And I would like to bring forward the case of federal court case of Syarikat Bekalan Air Selangor against Tuan Ipua, where it had affirmed in the case that media individuals can rely upon this defense, my lord, and as long as it is made in the interest of the public. And Reynolds case also mentioned what is matters of public, where matters of public interest must relate to things affecting public life and also matters affecting matters crucial to their interests. And we believe that issues of vaccination is an issue of public interest, where it is actually affecting the public life, where we can see that there are already 98% with bad side effects, and 2 persons are in ICU and 1 person are already dead. And therefore, this issue of vaccination, this issue of vaccine is actually a matter of public interest. And I believe it is crucial for Dr. Chua to actually make the statement, my lords. And there are 2 tests that to confirm whether this respondent can apply this defense of Reynolds privilege. The first one is the duty interest test, and the second one is the responsible journalism. I believe that has been said by the appellant. And duty interest test, the test was laid out, the question regarding this test was laid out in the case of Stewart against Bell, where it was asked that to employ the duty, would a reasonable person endowed with the standard level of intellect and who upholds moral principles agree that the communication be made? And my lords, as a reasonable man with moral principles, surely I would agree myself that the communication to be made whenever any man receive a letter claiming that a public interest is at risk, is being deceived by a particular party, is a matter of public interest. I'm sorry, my lord, but I believe my time is up. Can I just wrap up in just 2 minutes?
Yes, please. Okay with me, Mr. Xavier.
Yeah. Okay.
Yes.
Thank you, my lord. And move on to the legal, moral, and social duty of the Dr. Chua in communicating to the public and also to inform the public about regarding the allegations made to Vaxfarm. I would like to quote a case where Dr. Syed Azman, Syed Nawawi against Dato Sri Haji Ahmad bin Said, where it was held that public has the corresponding interest in receiving information regarding matters of public. And in that case, where an Ahli Dewan Undangan Negeri and Adun it was held that he had a duty to make the statement as he did in publishing an article, and the public has corresponding interest in receiving it. And similar to this case, Dr. Chua, not only as MP, we can disregard the point that he is an MP. He is the owner of Eastern Care. I believe that if he remains silent, a lot of repercussions, a lot of consequences, bad consequences could also happen and tarnish his reputation. Not only he already made the statement, that could also tarnish his reputation. He was being brave to omit the statement. And if it's if the statement was not proven true, Vaxfarm could already clarify it and not sue for damages, sue for defamation and all. And we further submit that the presence of the official stamp of Vaxfarm was and revealed as the former director of the R&D of Vaxfarm involved in the clinical study is sufficient enough for the to pass the test of responsible journalism. I believe the appellant counsel has stated the case of Tuan Ipua and the case of Malaysia Kini, where they had not taken the reasonable steps. But the main gist of the case today is that Dr. Chua only made the press conference 3 days after he received the letter. We believe that in such a short period of time, it is hard for him to either hire a detective or hire someone to actually check, to actually ascertain to what level the letter is true. And we believe that he made the press conference in good faith, my lords. And therefore, not only that, my lord, I would like to quote Lord Nichols in the Reynolds case itself, where it was stated that the 10 points or 10 factors of the responsible journalism is actually illustrative and non-exhaustive. And the weight of these questions and other factors will vary from case to case. And we believe, my lords, the duty and interest case is must be put must be put much higher than the test of responsible journalism in our case, because it matters of public security, my lord. And if I have no other questions from the bench, in the light of this submission, the respondents respectfully pray for the Court of Appeal to accept the submissions and dismiss the appellant's appeal on all the grounds that have been stated by the counsels. And with that, the respondents conclude our submissions, my lord. Much obliged.
Thank you, counsel. Is there any reply from the appellant? Are they entitled to a reply from the appellant?
Yes, my lord.
My lord, may it please the court, the appellant has 4 points to reply to the respondent in this rebuttal. First, according to the submission by respondent, the identity of the anonymous writer is a crucial amendment and the application was done in a reasonable time. However, the appellant wants to highlight that the identity of the writers cannot be said as crucial, while it did not bring any cause of actions into the pleading, as we mentioned during our submission just now. Besides, by applying the case of Hong Leong Finance Berhad, the case that respondent mentioned just now actually stated that the applicant should provide a reasonable explanation for such delay. However, the explanations by the respondents is not persuasive when it should not be take the period of 1 year to discover the identity of the authors, while they already have the knowledge that the writer is one of the High Committee of Oxfam. Hence, the amendment of pleading should not be allowed because it may lead prejudice to the appellants and also may be seen as an abuse of process of the court. Also, there is a lack of bona fide for the intentions due to the undue delays from the respondent.
Well, but counsel, can you address me on this one point? Your client was not completely true regarding, it was not forthright. It did not tell the truth regarding the efficacy of its vaccine trials. Now, in the event that is true and correct, that the efficacy of the vaccine was suspect, I believe that Eastern Care wouldn't even have entered into that contract. Now, what is your answer to that? What is your client's answer to that anonymous note, essentially? The note says that your client wasn't telling the truth regarding those trials. Now, had that come out and been made known to Eastern Care, they wouldn't even have executed the contract.
In regards to this, the Dr. Chua did not take any reasonable steps to verify the identity and also the truth of the vaccine's efficacy results. My lord, may I proceed to my second point?
Certainly.
The respondent contended that the contract is frustrated due to the change of eligible groups, causing a radical difference in the contract, and the contracting parties are not responsible for the change of law. The appellants want to highlight this, that the amendments on the eligible age groups did not render any fundamental change of the original obligations, because there is still a large population of the public still able to apply the MAVAX vaccines. And it is actually the duty of the respondent to take subsequent actions to encourage the public to take these vaccines instead of claims for the frustrations of the contract. My lords, I noticed that my time is up. May I?
Okay for me, Miss Ng. Okay for me, Mr. Xavier, Mr. Yi.
Okay.
Yeah, fine. Yeah.
Fine.
Because I interrupted you, please.
Much of that. Besides, the amendment to the license matched by the Drugs Control Authority is not the suspension of the license, and it's just a small amendment in the eligible group. And the authority has also given the promise that the vaccine is still safe to be used. Therefore, it did not prevent the parties from performing the contracts. Therefore, there is no frustrations in this contract. Thirdly, the respondent submitted that another test to determine whether a statement is defamatory when Dr. Chua also holds a public office. The appellant wants to point out that the normal test of whether a statement can be is defamatory can be used here because the test suggested by the respondents will also bring the same results with the normal defamatory test submitted by us. The result of the defamatory statements by Dr. Chua already produced a bad impression on the mind of the public and tarnished the reputations of appellants. Also, Dr. Chua made the statement with malice, as he will definitely make a statement in favor of him and Eastern Cape. Of course, Dr. Chua can make a statement, but the statement cannot be defamatory to any parties, including the appellants. Therefore, we again submit that the statement made by Dr. Chua in the press conference is defamatory and referred to the appellants, and it fulfills all the elements of defamation. Last, the respondent submitted that Dr. Chua has legal, moral, and social duty. The lead counsels of the respondents, when answering to my lord's question just now, she said that Dr. Chua called the readers of the letter, and following that, she said, of course, that is not enough. The appellants wants to highlight that the respondent already agree with our stance that Dr. Chua failed to take reasonable steps to verify the identity of the unknown reader. Also, we again want to highlight that no matter which capacity Dr. Chua is during the press conference, he still failed to take reasonable steps to verify the identity and also the truth of the vaccine's efficacy result. Therefore, the appellant submits that Dr. Chua failed in the test of responsible journalism. Due to that, there is no legal, moral, or social duty under Dr. Chua, and Dr. Chua is not entitled to the defense of Reynolds privilege. That concludes the apparent rebuttals. Much obliged.
All right. I think that's all done for now. Anyone else? I think there shouldn't be.
Mr. Gavin, we have to hear from the respondent for their rebuttal.
Oh, the sir rebuttal. I see. Okay. All right. So respondent. Ms. Kaur, Mr. Zafran, who will be leading?
Me.
Yes.
Please, my lord. Okay. May it please the court. The identity of the I will now address the points made by the appellant in their rebuttal. Now, identity of the anonymous writer is crucial and were done within reasonable time. If they said it can't be, if they mentioned that it can't be said as crucial amendment, then there should be no prejudice caused. On the other hand, if the amendment pleading is allowed, both parties still have the chance to defend themselves as it is still in the middle stage of court proceedings and there's a reasonable amount of time left. Now, in the interest of justice, if an amendment of pleadings is relevant to the case and necessary for a fair trial, and any prejudice caused could be compensated by cost, it should be allowed to be added. And it isn't the respondent's fault that the knowledge on the writer's identity was only disclosed after a year. It is in the hands of the writer himself it's in the hand of the writer himself
divulge his identity.
When he feels safe to do so. And sorry?
No. I was just hanging on to your submission. Please proceed.
Appellant's concern about undue delay can be compensated with cost. And as for frustration, of course, the issue of reduced targeted market is taken into consideration, but our submission extends way beyond that. And it is the fact that the contract was made considering the efficacy of Mevax vaccine, which was concealed by Vaxfarm. If the respondent had known about the actual efficacy, the agreement of 100,000 doses would not have been made in the first place, as other suppliers also supply vaccines to Eastern Care. And radical difference has been established and rendered the contract frustrated, as the change in law makes it unlawful and then impossible for the vaccines to be sold to anyone aged 12 to 17 and 65 years and above, which includes two different age groups being excluded from being eligible to take the vaccine, compared to what was originally taken into considerations when getting into an agreement. Hence, this radical change rendered the contract frustrated and freed Eastern Care from the obligation to pay the balance 50% of payment, as that obligation only arose after the frustrating event and thus is void. And the appellant keep pointing out that it is the respondent's fault that the public view Vaxfarm negatively, but that the same could be said, they could be said to be equally at fault, since Vaxfarm remained silent on the issues regarding side effects of it and didn't attempt to clear the public's misunderstanding when it went viral. Of course, we acknowledge that Eastern Care also remained silent, but that's because they are merely the purchaser of the vaccine. What else are they supposed to do? But Vaxfarm conducted the clinical study where it was later discovered that they concealed the truth about the results. And the statements made by Dr. Chua is not defamatory, as the name is not even mentioned. Dr. Chua is also risking the reputation of Eastern Care as the hospital which purchased the vaccine by holding the press conference to the public, but still he disclosed the matter to the public because he believes that he has a moral duty to do so. Plus, it is not the first time he speaks on public interest issues, especially public health. So it's really unfair of Vaxfarm to say that he said defamatory words about them when he didn't even mention their name, and it isn't his fault that the public assumed it's Vaxfarm, because Vaxfarm has never attempted to clear the misunderstanding regarding the efficacy of the vaccine, and instead they simply relied on the amendment made by the Drug Control Authority to guarantee the safety of their vaccine. And also, as for the Reynolds privilege, we have contended that with good faith, respondent believe the letter is something that is already verified with the official stamp, although we failed to get confirmation through phone call, but later on proved to be the former director. We have used 2 other tests to determine whether it was relevant for Dr. Chua to communicate the facts in the letter, which are the duty test and interest test. And yeah, if explanation was indeed sought from the appellant, the respondent might not get a true response, as up until now there's no statement was given by the appellant. So the respondent is eligible to raise the defense of Reynolds privilege, and that is all from me.
Thank you, counsel. Okay, are we any other questions?
No, none from me.
No.
Okay, none from me also. Do we decide on the matter, or do we just mark them and?
There should not be any decision made, because we have the method of choosing which team.
No, that's okay. Insofar as the scoring is concerned, I thought we have to allow the appeal or dismiss the appeal or whatever.
That's not required, Mr. Gavin.
But okay, fine. So that is unnecessary. Can we just talk to the students, or?
For the feedback session, is it, Mr. Gavin?
Yes. Is that now, or?
We should have our deliberation session now, and then after this, our feedback session, or if the judges would like to have the feedback session first before the deliberation, we can do that also.
So let's deliberate first, and then we can do it from there.
All right. This hearing session is now adjourned. The judges will be given 10 minutes to deliberate, while counsels will be directed to the waiting room. And counsels are reminded to not leave the Zoom application, as you will be brought back into this breakout room for the feedback session. You will enter this breakout room only when you are instructed orally by our technical team. Counsels, you may now leave this breakout room. Thank you.
Thank you all.
Thank you.
Gents, okay. We should have done it like the genuine court of appeal. Interpreter, letak dalam breakout room.
That's right.
I thought it was a very, I must say, I'm really impressed with the children. Well, not children, the up and coming law students, man. If I could be half as good as them when I was in my first year, second year, third year, wow.
Yeah, I think it's quite good. The quality was quite good. Yeah.
Yeah. So yes. I mean, truth be told, I think they can surpass some of the lawyers we see nowadays who come on and just blabber on for a few minutes, get shouted at, and then go home.
Yes.
So I've got to give it to them. I've got to hand it to them. Very good. I think I would partially allow the appeal insofar as the frustration is concerned. I don't think they've made that out completely, but defamation and all that I would dismiss.
Yeah, agree.
I think the defamation aspect I would dismiss insofar as the partially allowing only for the frustration. I don't think the frustration was fully made out.
Yeah.
What do you all think?
I agree. I think the part of the contract where they can still perform surely cannot be frustrated, is it? It only be the parts which have been banned by the authorities. I think that clearly has been frustrated. Yeah, I don't think the defamation is made out, and I also would allow the amendment.
Yeah.
Yeah, because it's about It's just a matter of introducing an additional fact. I think there's no prejudice in that.
Correct.
Yes, correct, correct. Yeah.
I think the frustration would have been made out if counsel for the respondent had emphasized the point that, look, end of the day, these fellows misrepresented to us the efficacy of the vaccine. But I didn't get that so much, you know.
Yeah, maybe because they were confined by the the moot question,
Yes,
which did not give an opportunity for a counter claim for misrepresentation, you know.
Correct.
Yeah.
Okay. So that's my view. You gents share the same view?
Yes, I agree with you.
Yeah. So, Believe, do we put in our scores now?
Yes, judges.
Okay.
I've put in while they were ongoing, so I just save it. I click file, save, right? That's about it.
Actually, we have received your scores, Mr. Gavin.
You have mine, right? Okay.
Yeah.
Okay. Right. So I'll close it then, huh?
Yes.
So how do I submit? I already fill it in.
All right, Mr. Yi.
Just email back, is it? Or what?
Oh no, actually, Mr. Yi, did you download the file?
Yes, I actually downloaded it.
Oh, actually, you can just fill in through the Google Docs. Could you access that?
Oh.
So Victor, if you just double click it, it opens in a new tab. Then you amend it directly onto the document.
Oh, all right.
Okay, so gents, are we good to go back in?
Just 1 minute. Let me just save this, Gavin.
Okay, no worries.
Yep. So if I just close it, it will save, isn't it, Believe?
Yes.
Yeah, it doesn't have the save.
Yeah, it does. It's a save button. Okay.
Believe I will submit later. Is it okay?
Since you have the downloaded
I'll just email
document,
you later lah. I just email the secretariat later, just to save time. Is it okay?
Because we need your documents now, because our team have to tabulate the data for the announcement of the finalists later, because our final round will start at 11:30.
I've closed mine. If you want to check whether it's there.
Yes, we have received your score sheet.
Okay.
Okay, I'm having difficulty amending on my browser because.
Mr. You can send the downloaded file through the chat box, Mr. Yi.
Oh, through the chat box. Okay, all right.
You know, I think this is just emblematic of how all of us are growing older. The other day, I tell you, a bunch of first-year students had an assignment where they need to talk to a lawyer in practice. So they called me and they asked me, they were first year, so talking and all that. And I said, I was in my first year in 2006, 2007. How old were you all that time? 5 years old. In that moment,
it hits you, isn't it? It really hits you.
Dinosaur.
Yeah, it hits you hard.
I was thinking, they'll say maybe they were 15 or 20 or what. And the bugger tells me I was 5 years old. It's one of those things. Sorry, Miss Lim, Faiz, how old were you in 2006?
2006, I was 4.
Did you have to go there, Gavin? Hey, Gavin. Gavin, I don't seem to have your mobile. Can you privately in the chat group send me your number? Let's meet up soon.
Sure. No worries, mate.
It's been a long time.
Yeah.
Really, if I also cannot send it through the chat box.
Wait, let me just put it here. I say, Victor, could I have yours also? Then, you know, it'd be nice to meet up with you fellows.
Yeah.
also.
Can.
Then when did we last meet, Xavier? I think it was in court only once or twice, right?
Yeah, we just bumped it, but it was a short, brief one only. We should catch up for lunch or something, lah.
Yeah, exactly. Oh, actually, I have yours. Oh, but it's your office number.
Okay, never mind. I'll send you a text in a bit.
Sorry to interrupt, judges. Mr.
Yes.
Victor, you actually sent the phone number direct to me. You should click the two to.
You have to select
everyone. Okay,
Oh,
okay. Sorry lah, a bit
HR2.
noob here lah.
It's okay.
Oh, I
Yeah,
see.
Mr. Victor, you are not able to send me the
Yeah.
score sheet through the chat box, is it? You
I
know
just
how
cannot send to everyone.
Huh?
Oh my goodness, sorry man, I'm wasting everyone's time. Can I just email it? Billy?
Sure. You can just email. Wait,
okay.
I will paste the email for you. Hang on, yeah. Sorry for that.
Mine's 017-295-2459 lah.
Got it. Thanks.
Okay, thanks, gents.
Okay.
Mr. Victor, do you see the email? You can just send the score sheet to this email.
All right.
Thank you, Mr. Victor.
But sorry, judges, my apologies. Before we proceed, we would have to confirm that we have received Mr. Yee's score sheet first.
No problem.
Okay, I sent already. Sorry guys, taking up your time on a Sunday morning.
Oh, no lah, no worries at all. Okay, Xavier got it.
Okay.
Victor, you're with Nimalan and all that, I suppose.
Yes.
Okay. Nimalan and I've known him for quite a while also. In fact, we had just resolved the matter. Well, resolved, I say resolved, but my client was arm twisted a little bit by another co-defendant.
Oh no.
Yeah. It was before Lisa Chan.
Oh, Lisa Chan.
Yeah.
How is she?
She's all right. I think she's got a good grasp of the law, but once she makes a decision, whichever way, she'll find the law to craft to get that decision. So in my matter, I personally think, I've been before 3 times. I think that, so not Nimalan's matter, another matter, I personally think she was wrong, but she wrote it in such a way that she seems right. But when I read the case she's referring to, it's not correct on the law.
So who is this, Gavin?
Lisa Chan.
I see, okay.
Yeah. So here and there, I would say that she's a good judge if you get her on the right day. Yeah. So Billy, if you want to admit the rest of them, Victor, is your thing in already?
I've sent already.
My wife is asking me, giving me a look now, saying, can you hurry up? Because I want to go to the market now.
Lim Kian, is it in?
Yes. Sorry, we are checking from our teams, Mr. Victor.
No problem. Take your time.
Sorry for that.
It's okay. The market is open until 11:30.
Hey, when you're knocking off for Christmas, Gavin?
Ipoh.
Oh, Ipoh, nice.
Yeah.
Balik?
Next week, 24th lah.
Wow. Christmas Eve, you're traveling.
Yeah, no choice lah. My wife's work and all that, so it's gotta be a last minute thing lah. You know, go there for the weekend and all that, then come back. Yourself?
23rd, I'm heading to Penang.
I see. Right. Okay lah. So 23rd shouldn't be too bad, hopefully.
Yeah. Vida, what are your plans?
I'll be here lah, probably.
Yeah.
Because I went back my hometown already.
I
in
see.
October.
Where's your hometown, Victor?
Terengganu, bro.
Oh, Terengganu. Wow.
Yeah.
It's a bit of flooding there now. I mean.
Now monsoon quite bad also.
Yeah, you know, I've never seen the rain like what it was yesterday. In my whole life in Subang, I've never seen rain like that.
Yeah, Subang is really quite mad. Yeah. Yeah.
I think this is climate change in effect right here, right now,
Must be,
Yep.
must be.
Yeah.
My wife was right in smack on the way from Subang to KL when they shut off all the highways, the tolls, and all that. So she was absolutely panicking. So I had to get on Google Maps. She shared her journey, and I guided her to out of that whole Subang enclave where the roads were closed back to KL. Took her an hour and a half to get back to KL.
My goodness me, really?
Yeah,
you know how terrifying it is, the water
I know.
levels.
It's terrible. Like, she was panicking like crazy, and I had to. I stayed on the phone for an hour and a half, guiding her through the roads to get back home.
I see. My goodness me. Her GPS was non-functioning, or
no? I think she was a bit panicky, So she couldn't route herself, and although the roads were showing one place, but the authorities had blocked it, so
I see.
it was still taking her back on that road. You see?
I see.
Yeah.
It'll double you back to come back.
Come back there. So I had to find an alternative.
My wife left at 1 yesterday. She saw the rain getting out of control. She thought just leave early lah. So she closed up and she just left, and thankfully avoided the whole thing lah. Goodness me. It's
Faiz, are we holding up anything, Faiz?
No. Mr. Victor, we have received your email, but it seems that you haven't filled in the feedback section.
I've already sent another one in the chat box.
Lim Chen, you received it?
Yeah, I'm opening. Hang on.
But
the score is all there. The score is all there.
Oh, Mr. Victor, but the new file that you have sent, I also didn't have any feedbacks filled in.
Oh my goodness.
Did you save the word file after you fill in?
Or if you drop it in the chat box here?
Yeah, already
okay, hold on.
All right, no worries.
Just give me 1 minute.
Okay.
Xavier, if you don't mind me asking, you're not related to Nanda Balan or anything like that, right?
Why?
You're channeling his vibe very strongly.
Exactly. I appeared before him the other day. Oh, you might judge.
Doesn't he seem similar?
Yeah.
The demeanor, the bearing, the haircut.
Well, I applied before him about 2 months ago. I didn't succeed, so the vibe is not working with him,
I see. But really, honestly, the way you asked the questions, also, I was like, wow, I'm getting Nanda Balan vibes here. Justice Nanda Balan and you similar. I thought.
No relation other than my daughter taught my wife taught his daughter in school or something like that. Yeah.
I see.
But no relations at all.
I see. But with Indians, you could be some relative somewhere, and you could actually be related.
You never know, right? You just never know, right?
It's one of those things, lah.
Right, judges, we have received all of your score sheet. Can we now proceed to the feedback session?
Sure, no problem. Thanks, Faiz. The only portion that we allow the appeal will be vis-a-vis the frustration of the contract. We think that premised upon the facts, the frustration of the contract has not been made out. So in that aspect, the appeal is allowed. There will be no order as to costs. All right. Thank you, ladies and gentlemen. Now, is it the feedback session, Faiz?
Yes, we can proceed to the feedback session.
Gents, do you mind if I give my views first?
Yes, go ahead.
Yeah, go ahead.
Now, first and foremost, I'd like to congratulate all of you. I thought that was a fantastic submission, well-paced, well-structured, and I must say far better than when I was a first-year lawyer, second year, even lawyer, I would say. I only have 3 points for the four of you. The first one I would suggest would be to use a core submission when you outline your arguments. Now, what I mean by a core submission is this. when you start your submission, try and lay out one major point that you have. Almost every matter, no matter how complex it is, will only turn on 2 or 3 points at most. The most complex matters will have only 3 points. Simple matters will have 2 points, 1 point. Now, what I mean by the core submission would be something like this. For example, for the appellant, it would be simply to say that Eastern Care manufactured a scenario to frustrate the contract. And then you lead on to it by saying things like, for example, first, they didn't want the contract. They didn't want the balance because there was a problem with it. But the government supported it. The government never said it's impossible. Then you go on to the fact that Dr. Chua goes as an MD and makes this statement to further disparage the brand. And then the third point, after that, he comes and finds this anonymous note, which we don't know anything about. Then they come and amend. So you paint the facts in a way that makes us think, oh yeah, actually, it is them trying to lead facts to frustrate the contract. So then that's got it in my mind. So the appellant, you have that unique position. You can frame your core submission around those facts. So it gives us a storyline to follow. Oh, this is the story. Okay, yep, this makes sense. Okay. A respondent also, you can do something similar. My core submission would simply be that they gave us a vaccine which they knew to be ineffective because they had that information right off the bat. Okay, and to lead into my argument, I have 1, 2, 3, 4 points. That is my suggestion, to use a core submission right at the top. So it catches my attention. Okay, the second one would be pausing and slowing down. I think when you're submitting, especially I think for the respondents council, your speed was a little bit quick. Now I know that you want to get the point out quickly, but you need to slow down and make sure we appreciate the point. If you make the point, but it's not appreciated, if it doesn't sink in, it doesn't get absorbed, and I don't take it on. Even I think Miss Ng, towards the closing, your rebuttal, you made some very good points actually, but you said it so quickly. And I know there's the time limitation. So when there's a time limitation, maybe try to limit yourself to just 1 point. Your killer point, that's the #1 thing you want to go for. Okay, the other point, it's just to do with enunciation. Now, certain times you may find certain terms difficult to pronounce. I think that's something to work on by yourselves. So for example, so certain terms that I heard may not have been pronounced properly. So those are things that sometimes detract from your overall presentation. And why I say that is because when you're in the flow and I'm listening attentively, and then I hear one word that's a little bit out of it, it throws me a little bit. So for example, if I'm listening to it and I'm listening attentively, and then there's a mispronunciation of a word, or a word is well, I can't say misspelled, but mispronounced essentially, or the grammar and syntax is off a little bit for that one word, that throws me off the submission, because then I fixate on that one word that was mispronounced. And I learned this from one time when I went before the Court of Appeal, and I used the term viva voce. It was viva voce evidence, but I went and said viva voce or something like that, something ridiculous. And it didn't strike me until I sat down, and then my junior told me this term was mispronounced. I said, oh, okay. And I then, she told me it threw off the submission, but you know, thankfully the appeal was allowed. But that was one point that I think I need to make clear. So those are my 3 points. Otherwise, congratulations to all of you. I think it was very well done. You can just wait for your scores then.
Xavier, you want to go first?
Sure, thank you. Yeah, I agree with Gavin that all of you did very well. I think there's a lot of work put in. Clearly, preparation was done, and that's appreciated. You know, council work, when there's no preparation, is always telling. You can tell very quickly when council is not prepared. So all of you were very prepared, and that's good, and that's how you should be when you become practitioners overall. I think Gavin has covered some points that I had, but so I'll avoid that. Maybe I would like to address the issue of answering questions by judges, right? So when judges ask questions, it really means that these are the areas of concern. This is what that's bugging them, right? And they need that to be resolved so that they can buy into your argument. And so it's a clue into what problems they may be having with your train of logic or legal arguments, right? So some of you all did that very well. You answered the questions squarely, and that's good, and that's always encouraged. But some of you may have tried to sidestep the questions, or may have preempted the question and had prepared answers, right? So you have two judges asking the questions from different angles, but essentially the same questions. The same answers were being peddled. If the question is being rephrased, that means they were not satisfied with the first answer. And so you got to pick up, because then it tells you what's bugging the judge, which angle is this judge coming from, and what matters to the panel, you know, and you try to address that squarely. Sometimes that's the only point you need to address to succeed in your case. So take questions very seriously, and don't just answer them with prepared answers, but really try to say what is bothering this judge, what is the real question the judge's mind, and then answer the question that way. So maybe that's that. I think yes, I think some of y'all were very earnest in your presentation, but maybe sometimes a little bit too much reliance on the written submissions, because I read the written submissions, and some of you were actually reading off maybe a summary version of the written submissions. Written submissions are there for the judges to read, and it's a guide for you. But you should be pliable, should be flexible enough to deal with the real issue that comes up at the hearing. And sometimes it might be outside the scope of the written submission. So don't try to pull back the judge to the written submissions all the time. Focus on the judge. What matters to him or her? Address the judge at that point, even if it means that you have to depart a little bit from the four corners of your written submissions, provided you're consistent all round with the position that you are putting forward. Those are my points.
Hi. First and foremost, well done to everyone. I echo what my two learned brothers say. I don't want to take much of your time. I wish all of you all the best in efficient undertaking. Thank you.
Thank you, panel of judges, for the constructive feedback. Before the judges and counsels exit from this breakout room, we would like to have a photo session to commemorate on this mooting competition. I will now pass the floor on to the person in charge from the technical team.
Good morning, I'm 𝐃𝐚𝐭𝐨, the technical team of this hearing room. I will take the group photo now. Everyone, please kindly look at the camera. I will now count to 3 before taking a photo. 3, 2, 1. Done. Thank you for cooperation. I shall now pass the floor back to the baby.
Thank you, Shubha. Thank you, panel of judges and counsels. We are honored to be part of this competition with all of you. And your presence today has enabled us to ascertain the quality of the competition and provide a fruitful experience for the participants. The judges and counsels may now exit this meeting, and we will announce the finalists shortly. Thank you.
All right, everyone. Take care. Have a good day.
Everyone.
Thank you.
Bye-bye.
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 Catch up with you. Bye-bye.
Bye.
Thank you.
Thank you, judges.
Thank you, judges.
Just one question. Do we leave the meeting or do you just leave the breakout room?
Masuk breakout room dulu ke Zafran?
Alright.
Apa bercakap? Zafran, masuk. Okay.
Oh my God. Good job, good job.